I'm joined today by two experts, actually. So initially we had Maureen Taylor agree to join us, and I reached out to Dying with Dignity Canada when I wanted to host this event on assisted dying, which is timely, I think, because of the conversation that is the Justice Minister and the government is currently in the consultation that they're currently undertaking to fix the law. And Maureen was recommended by Dying with Dignity Canada, and for good reason. Maureen is a physician assistant here at our local hospital, Michael Garron. She's a professor at McMaster. You recognize her as a broadcast journalist, because that's what she was for 25 years before she undertook a second career. And she comes to assisted dying by way of a personal experience, which I'll ask her about and she'll speak to. But she was also the co-chair of a provincial expert advisory group on physician-assisted death as well. And then once we posted this event and we were asking folks to register, Kevin Reel reached out to us, and not to register, but to say, I'm a constituent, and here's some experience that I have, and if there's any way that I can be involved. And when I read that experience, I was very interested in having him involved, because he's the program director for the Joint Center for Bioethics at U of T. He's an author in this area and as an academic, a practicing healthcare ethicist, and MAID coordination is part of his daily work. And what stood out to me, and why I was really interested in having Kevin join us up here, is he regularly meets with individuals as they make formal requests for MAID. So with that and a little bit of an introduction, we are now at a point where our government had passed a law, and that law was deemed unconstitutional and in need of fixing. And I want to get to how we can fix that law and then go above and beyond, hopefully, where the courts have asked us to go. But first, this conversation is often very personal for people, and I want to ask how you've come to become an advocate for assisted dying and become involved in this issue.
Thank you very much for inviting me tonight, Nate, and what a great turnout. Thank you, and it's nice to see some CBC alumni here, as well as a colleague from Michael Garron, Dr. Workington. So my name is Maureen Taylor, and I came to this through my late husband, Dr. Don Lowe, who some of you might remember from our last coronavirus outbreak in Toronto, SARS. And Don and I were kind of a post-SARS love story. He used to say that SARS was terrible, took a terrible toll on people, but one good thing came out of it, and it was like me, he said. So I was the CBC medical reporter at the time, and I was interviewing him for 3 months straight because of SARS. And he was such a, maybe you remember, a kind man. He was so good to his children and his family. And we were deliriously happy when in 2003 he had these vague symptoms, just really felt like a sinus infection right after we got back from a trip to Myanmar. And being a doctor, kind of just thought, oh, sinus infection, do I treat it with antibiotics? Probably not. And finally diagnosed with a brain tumor. A bad brain tumor in that the place where it was, you couldn't operate on it at all. So he knew that he had less than a year to live. And he knew what his death would look like, because this brain tumor would slowly take away his ability to eat, swallow, see, walk, talk. And it was 2003. We weren't even aware that at the time the Carter case was making its way up through the Supreme Court. The real heroes of the Canadian legislation are Gloria Taylor and Kay Carter from BC. But Don asked me, I think within 2 days of his diagnosis, to look into Switzerland, which we all know is code for, I need an assisted death, where can I get it? And I looked into that. It's very complicated. You need at least 6 months to make that happen. So that wasn't available to us. And then I looked into acquiring the drugs illegally online from China or Mexico. But at the end of the day, we weren't sure we could trust those. And he died 7 months later, in our home with palliative care. And I want to say this plainly as I can. I am a huge proponent of palliative care, and Don got good palliative care, but that wasn't how he wanted to die. He died with terminal sedation, where they put you into an induced coma so that you don't know that you're suffering anymore. And I laid beside him for, 8 nights like that. And he died at home, which was what he wanted. But I decided after that, watching him suffer and knowing what he wanted, that I would advocate for assisted death in Canada. And then I became more involved and more knowledgeable about the Carter decision. And I was very, very happy to see it passed. But, and we'll talk about this, there are some gaps.
And Kevin, you indicated to me, I mean, this is part of your daily work. And how did you come to this issue, and what is it like on a regular basis to be engaged with people who are making these decisions?
Well, I came to the issue that this issue in Canada because I was working as a practicing healthcare ethicist since 2008, and almost every one of us had to deal with it. So I came to MAID because of the role that I was in, but I came to the idea of assisted dying because for almost 30 years I've also been an occupational therapist. So I have supported people with various disabilities, both physical and psychiatric, to try to find meaningful lives. And that's been very successful in many ways. Been very proud of that work and very delighted to meet the people I worked with. But I also, in that role, met people who would say, a minority of them, would say that I've had it, and I just don't want to deal with this anymore. And it always just made certain sense to me that for that small group of people for whom trying to find meaning and purpose is not going to happen, and they're ready to actually say, it's time to go, it makes sense. And when the law changed, became involved in it in a number of ways. At the time when it became law, I was actually working at the Center for Addiction and Mental Health as their ethicist, and involved in the debates there, and gained a really acute understanding, I think, of why it is so complicated in the field of psychiatry, especially for the practitioners. And it just has carried on from there. And in my current role, I work between Sunnybrook Hospital and Markham Stouffville Hospital, and in both contexts, the ethicists are the ones who coordinate the MAID requests. So I do quite regularly go to see people who are wanting to sign the forms and meet them, and on occasion will actually be present when MAID is provided.
And in some ways, the legislation that came forward early in the last Parliament moved Canada forward when compared with other countries around the world. I mean, brought us in line with sort of catching up to where Oregon had been. And yet, when I read that Carter decision, and by way of background for me, I mean, before politics, back in 2011, I did my Master Laws at Oxford, where I wrote my thesis on Section 7 of the Charter with specific reference to assisted dying. And when the legislation was drafted, I was going through and thinking, okay, Carter criterion. For someone to be eligible for medically assisted death, there needs to be grievous suffering, there needs to be an incurable illness, and the individual needs to be of a sound mind, have capacity to make a decision and understand what they're agreeing to. And then the legislation added an additional criterion for a reasonably foreseeable death. And I thought that can't be right, because there are going to be people who are eligible on the other criteria and are now no longer going to be accessing an assisted dying regime, and their individual liberties and the security of the person are not going to be respected in the same way. And so we have an opportunity to fix the law. And I wonder, given both of your experiences, maybe speak a little bit to getting past, now there's a Quebec court case that has struck down that reasonably foreseeable criterion, and the government's been tasked and has agreed to fix the law. What else do you see as deficiencies, and where we might go next, and how important is it to remove this criterion that the government put forward in 2016?
Well, reasonably foreseeable death, anybody could reasonably foresee that was not going to be constitutional. I think it was a sneaky way to bring in Oregon criteria without using prognosis of less than 6 months to live. We don't have to revisit it. Thank God the Quebec law has struck it down, and this government won the election, even with a minority, and they've said they won't contest it. So we'll have a rewriting of the law. They just need to drop that criteria. these people are suffering grievously. They no longer want to live. Why do they need that extra burden of their natural death being reasonably foreseeable? And I think the providers in the room would tell you that's a really hard thing to get your head, a definition to use anyway. We're very bad at predicting death in medicine. If you ask me what other things we have to get beyond, obviously the government said they would revisit the issues of people whose primary issue is mental health, and you'll be saying more about that, I'm sure. Children, or mature minors we should call them, and then the issue that I bet a lot of us are interested in tonight, and that's an advance request when you lose capacity before you can have MAID.
And Kevin, so we have, if someone is suffering incredibly and grievously and they have capacity and their illness is incurable, are there other safeguards that are required that we should be talking about at all?
It's probably the biggest one that people are also worried about is the notion of capacity. And that's where the debate about around advance requests becomes a complex one. And I think the safeguard of being capable is justifiable at the point where the request is made, which is, by virtue of the way our law works, it's actually at the point where you've pretty much been found eligible already. We just have to confirm that you're capable in this request, and it's not coerced. And it's the finding or the evaluation of somebody's capacity to make this decision that is probably the thing that very much distresses a lot of people in the world of mental health, because it can get very complex there. It doesn't mean that there isn't a way to do it. It does mean that there will be a lot of people who will probably be found ineligible because they're not found capable. And that happens now under the current law. But the problem under the current law, of course, is that when you make a capable request, but the illness means that you lose capacity prior to the date where you've made arrangements for provision, or sometimes you haven't yet made arrangements for provision because you're eking out as many days as you can, then you don't get the provision anymore. And it's that question about what could we allow in terms of advance requests that is one that's very worth debating, because there might be some very clear safeguards on that. And
that's an interesting segue then into the case of Audrey Parker, an individual who was deemed eligible for medical assistance in dying. She was suffering incredibly, having an incurable illness, and she was of a sound mind, and so she was eligible. But then she opted to end her life earlier than she otherwise would have wanted to, because she was worried about losing capacity, and because she would have had to have capacity right till the very end. Now, that's a form of advance request that seems to make eminent sense to me. That seems, in some ways, the easy version of advance request. So that is where someone is clearly eligible for MAID. There are more difficult potential cases where someone is, for example, diagnosed with an illness but pre-eligible, and then there's maybe a more difficult case where someone, say like me, who's concerned down the road, but I'm pre-diagnosis and pre-eligible, and it's hopefully not in any foreseeable future. So when we talk about advance requests in these three categories, the first category of Audrey Parker seems straightforward to me. Maybe speak to the other two categories and what your thoughts are, given your experience.
The second category, sorry, that you mentioned, where you have a diagnosis, but you think you will slowly lose. Well, let's just talk, we're all thinking about it. It's dementia. I mean, I'm not worried about getting a brain tumor. I'm worried about having dementia one day. And so people are wondering, when do I have to get MAID in order to be capable to make that decision? So that's tough. In Europe, there are some countries that allow you to make an advance request, but it's hardly ever done. And you'll read about one-off anecdotes in the news about people who said they wanted it, but then at the end they looked at the doctor and said, don't come near me or whatever. These are, as a provider, it would be horrible to think about that happening. And I want to be clear to anybody in this room who might help me have maid one day. If I am dancing around with a boyfriend in the old age home, but I no longer can wipe my bum or toilet myself, and I have a sacral ulcer that you can stick your fist into, I don't care how happy I look. I want maid, okay? Like, I'll be very clear in my advance request about that. But on the other hand, our provider's going to be willing to do it. And I think you can't force people who are already maybe conflicted about doing this in many cases to do it when the person cannot say yes to it in that moment. It's going to be tricky.
And Kevin, do you have any thoughts on the different categories of advance requests?
Yeah. I think you'll see in the film one of the men who's profiled has ALS, and it's quite likely that he could have lost capacity had he been in a position to request it, or had he requested it. And in those cases, I think it's probably got to parallel the way that advanced care plans work for any other healthcare treatment. I find it personally hard to make this that much more certain, so that in an advanced care plan that you've discussed with your substitute decision maker, or your power of attorney if you appoint one, the wishes that you have expressed capably in advance will only be followed if they're relevant to the circumstances at hand. And so if you specify a number of things that will mean I want now the providers to provide me with an assisted death because, again, in the case of dementia, which is what most of us probably fear quite a bit, but other people will argue it shouldn't be feared, you will maybe specify things like when I can't recognize my children or my partner or whomever, or I can't engage with the staff in a meaningful conversation or something like that. The trouble is, I still wonder whether or not, if you're dancing, Maureen, you probably don't have the sacral ulcer, which is the one I saw yesterday.
You'd be
the woman
surprised.
who had it yesterday was not able to dance. If you're dancing, and I use the example of my brother quite often, who will probably, if should he get dementia, of a certain route, because you never know what it's going to look like until you're there, and then you probably aren't watching yourself. He'll probably be the most popular person in the long-term care home because he has the entire Beatles repertoire in his brain. And he will more than likely just sing it constantly and entertain people constantly. And I would really struggle if he had made an advance request to think that he's suffering intolerably. So I wonder whether the advance requests at the point of considering provision must actually still objectively somehow be seen to meet the original criteria that are there. Because that's where healthcare providers are going to get churned up inside. They're going to suffer extreme moral distress, especially if you don't assent to it and if you resist it, which is what happens. It doesn't happen in this film. There are other films you can see online that give examples of this. And in those cases, the places that allow these advance requests wouldn't typically expect that they would follow through on it if the person's actually not at least assenting to it, which is what you do when you can't consent, but you're cooperating with it.
Now, for those who have questions in the audience, I think there are some volunteers we've got with cards. If you have a question that has not been asked that you're interested in my asking, put up your hand. Volunteers will distribute the cards and they'll be passed up here. As we wait for some of the cards to trickle up, when we talk about advance requests, which is I think really where the debate is in this parliament, I fully expect us to fix the Carter, to revert back to the Carter criterion to fix the law as drafted by the former AG. I think also it may be possible to move into advance requests to fix the Audrey Parker case, which is where people are eligible already, and we don't want the unfairness of people ending their lives early. I read the Canadian Council of Academies and went through a fairly lengthy report on considering advance requests, and one consideration that they brought to bear was this notion of certainty. So how are you certain about an individual's intention? And I wonder if we can cure that in some ways by ensuring that advance requests are subject to sunset clauses. So if the individual's advance request has not been renewed within a 5-year period of time before they are then before that decision is being made, does that not cure the certainty question to a large degree? And then really the action is what Kevin was speaking to before, the objective criteria of intolerable suffering, and how we determine that for someone else when they are not saying it themselves.
You mean so the provider who helped you, or whoever helped you come up with the criteria, would have to revisit you every 5 years or whatever to see if this is still your intent, and these are the criteria you want. But who are these people who have all this time to go track you down every 5 years? It's not the maid providers. They're run off their feet now. I mean, I want this in the law too, but when I start to think it through in a practical way, there are going to be a lot of, we'd have to put more resources into things than we have now, I think.
There's also I think that there's something to do with a time limit on how long an advance request would be valid. There's merit in thinking about that, and then the practicalities of it could be difficult. And good Lord, it might take some extra resources. I'm willing to have my taxes increased for that, and you can quote me on that if you need to.
At least one constituent. No, there are others too.
But the other thing is to remember that, like, where you become incapable, where you're then deteriorating, there may be other advance requests or advance care plans that you have in place that you can still take advantage of, so that there's this slightly twisted thing now where, if you have a certain kind of injury, traumatic injury, and you need some sort of life-sustaining treatment, your substitute decision maker can say they didn't want that, and then you just die. It might take a while, and it sometimes takes weeks, but you might die. And that can happen with a stroke or a motor vehicle accident or whatever else. In these other cases, you may not be so debilitated that you won't just simply go find food yourself. You may have a seriously damaged cognitive capacity, but you may actually seek food yourself. And you may be the kind of person, like was Margot Bentley in British Columbia, who was in a long-term care home, where she responded to the spoon full of food. And therefore the long-term care home would not stop feeding her, even though she had a very detailed advanced care plan that said, in such a state, do not give me any life-sustaining interventions. And they felt that feeding was not a healthcare treatment. And so that played out in the courts for ages. And she eventually died. So I think it just needs to be an incredibly nuanced and robust debate around what we might be able to do and what would work administratively in the end.
So we're starting to have some questions trickle in, and volunteers can keep bringing them up that have been completed. The first one, which I think is fair for me to answer and answer quickly, is, are you concerned that Jane Philpott and Jody Wilson-Raybould have come out against changing the law? And the reason those two names are there in part is because Jane was the health minister and Jody was the AG when the law was first drafted. My answer is fairly straightforward. I mean, I voted against this law. In the previous parliament, I earned the record. Samara, in brackets though, or in quotation marks I should say, called me a rebel because I voted differently from the government 37 times. Well, 9 of those votes were because I voted against the assisted dying law as put forward by the government. And so, to really simply answer the question, I have no concerns at all, in the same way I did not have concerns to disagree when they were in positions of great power drafting the law in the first place. In the end, whatever one thinks, at a minimum, we should be respecting people's fundamental rights to make these kinds of decisions for themselves. And the real action, I think, should be debating advanced requests and the practicalities of implementation. So I think it's a real interesting argument to have. If I want to have my rights respected and I then lose capacity, having a medical practitioner figure out if I'm intolerably suffering is a real practical challenge. I don't think it's a particularly practical challenge to determine whether someone's eligible regardless of whether they're near the end of their life or not. I mean, where someone has capacity, that should, where they're intolerably suffering and they have an incurable illness, I think that should be the end of it. Even if difficult for the doctor to do it, it should at least be legal. doctors should only worry about one's conscience. I agree it cannot be forced. I agree it cannot be forced, but at least don't charge with murder. I think, I don't know if you want to
I'll just say there was a lot of talk about doctors being worried initially. You know, let me just say too, we need more MAID providers, and thank God nurse practitioners are really stepping into some of the gaps. But the doctors were worried about being charged with murder if they didn't, follow all the criteria. I can safely say I think I'm right that no doctor has been charged with murder, and I don't even think there's that many CPSO investigations into this. Am I right, Kevin? Yeah. If there are, they're not really making the news. So, I think doctors and nurse practitioners are following the law and are doing a very good job.
So we have one person writing in just to, I think, reiterate that once it's agreed that the patient's of a sound mind, why can't that be enough and not the date of anyone's life? I think perhaps speak to the safeguards of Carter, and are those overly prescriptive?
Well, I would always say that the shocker for most of us was that it was required that you'd be 18 years of age. Which, if you just think about being a 17-year-old who's got a really incredibly awful illness, which would otherwise make them eligible, and you say, well, if you can hang on until your 18th birthday, then you can make a formal request and 10 days later we can give it to you. It just seems patently bizarre when you look at it that way, which is, of course, contrived to make it look bizarre. But the concern that there are going to be 12-year-olds receiving assisted death is really misplaced and overblown and misused, I would say, by those who like to rely on extreme examples. But there are currently people who are under 18 who make significant life-threatening decisions and life-ending decisions in their own healthcare because they're capable under our law, which doesn't set an age.
And it's interesting when you look at legal decision-making outside of the MAID context, we don't actually, oftentimes in medical decision-making, it really comes down to a contextual capacity determination, not a specific age determination.
It's also just to say that there are cases where people have been concerned about somebody who is under 18 making a decision that would likely end their life. And in some cases, when it's been investigated and the healthcare providers have actually resisted it and taken it to court to have a court decide, there are occasions where the court has found that the under 18 individual is actually being effectively persuaded or coerced by their parents' own wishes. And in that sense, they're found to be incapable because they can't decide for themselves because they've been so shaped by what their parents are thinking on the issue. So there are precedents for showing that the system does work, and if we want to change the system for assisted dying, it strikes me that we need to change it for everything.
And when we talk about mental health, we've focused in on dementia, which is rightly of concern to many. This author notes a different aspect of mental health, which is how is severe depression handled? Can and should it be eligible?
It's difficult to assess these things. Psychiatrists will tell you, and social workers will tell you. But there are people who have very clearly demonstrated to assessors that despite being profoundly depressed, their wish to end their lives is not by virtue of what you would call, or what is called in the industry, a cognitive distortion. There are very often people who are wanting to die because their brain can't work with anything else. Their mind is not seeing another route out. And in those cases, people would generally be found incapable. And I have psychiatrist friends who do the assessments for MAID currently to make sure that mental illness is not affecting somebody's capacity. And they do find people incapable quite regularly. But it's not at all impossible to imagine somebody who can actually say with a kind of both and, I know that I'm experiencing depression and I know these symptoms are by virtue of my depression. I can tell you that, and I can tell you that all the things I think that are really wrong are not actually as wrong as my mind is telling me. But that doesn't take away the grip of the depression. And even though I can rationally say to you this moment, I see that it's not real, it's my depression, the depression sits there and it won't go away. And we can't shift it. So it is possible to have rational thoughts within the state of long-term depression. Long-term depression is probably not the best example. There are a number of other things like personality disorders and schizophrenia and sorts of things that people talk about as examples of the kind of illnesses that, psychiatric illnesses that might lead somebody to request this, but may also, in many cases, lead people in their mind in places where they'd never even ponder it. It's not that common a request.
When we were discussing this at the provincial task force that I was co-chairing, this was the one that I really struggled with until I saw this documentary. So if you can keep an open mind and watch this, you're going to meet a character in this documentary who helped change my thinking on this. I would add that when the Council of Canadian Academies was discussing this, they felt that people with mental illness shouldn't automatically be shades of CBC, shouldn't automatically be excluded from under the law as a whole cohort of people who can never qualify, but that maybe there should be added safeguards for them, such as your assessments must be done by psychiatrists, and perhaps your waiting period should be different. So I don't know what else they pondered, but anyway, I admit that that's a tough one, but I wouldn't exclude them entirely off the bat.
And unfortunately, we are running out of time in order to get to see the movie. So for those who did not get a question answered, I will follow up by email. And I would note that, and I'll also make sure to engage Maureen and Kevin, because there were 3 people who all asked about, in different ways, the involvement of partners and family members in helping, or in some cases maybe problematically where those family members are resisting, and how those relationships play into the decision making in the end. So I just want to express my thanks to Maureen and Kevin for joining. Thank you all for joining us for our first of hopefully many events here at the Fox on a range of different issues, and I hope you enjoy the movie.